All right, welcome to another deep dive from Talk Testimonies. We break down complex Supreme Court cases, and today we're diving into Virginia House of Delegates v. Bethune-Hill.
Oh yeah, this one is fascinating. It really gets into the nitty-gritty of redistricting.
Absolutely, and the court ultimately decided to uphold the lower court's decision, saying that Virginia's House of Delegates district map was unconstitutional. The way they drew those boundaries for 11 specific districts, it relied too heavily on race.
So that means that for the next, well, at least for this decade probably, future elections will be using a court-imposed plan for those districts.
Exactly. But to really understand the implications, we have to unpack the core issue. What was it about those 11 House of Delegates districts that made the court say race played too big of a role?
Well, after the lower court ruled against them, the Virginia House of Delegates, they tried to appeal. Their argument was basically that redrawing the districts like this, it really hurt their ability to function effectively. They called it an institutional injury. And they also said they were fighting for the interests of the entire Commonwealth of Virginia.
Now, on the other side of this whole thing, you've got the folks who originally brought that lawsuit, Golden Bethune-Hill and others, and they were joined by the Virginia State Board of Elections.
And they had a pretty clear argument. The House of Delegates, they didn't even have the legal right, or the standing as it's called in legal terms, to even appeal that decision.
Right, and they totally agreed with that lower court ruling, that race, yeah, that was the main thing driving how those district lines were drawn.
It's kind of like they were saying, hey, you can't even argue with us about this.
Yeah, good analogy. And to make things even more interesting, the U.S. government jumped into the mix too. They filed what's called an Amicus Curiae brief, which basically means friend of the court.
And this is where it gets a little tricky. See, they didn't pick a side on whether or not the House of Delegates had the right to appeal.
Right.
But they did say that the lower court might have made a mistake in their legal reasoning, like the way they decided if race was the most important thing.
So basically the government's saying, we're not taking sides on who gets to argue, but if they do, the lower court's basic analysis might be flawed.
Precisely.
Okay, now let's get into how those districts were actually drawn. The House of Delegates, they argued they were going for a target of 55% Black voting age population, also known as BVAP, in those 11 districts.
Right. And their reasoning was that they were trying to follow Section 5 of the Voting Rights Act.
So think of Section 5 as a protection to make sure that states with a history of voting discrimination, they can't just weaken the voting power of minority groups.
But those challenging the map, they argued that just applying this blanket 55% target to all 11 districts, that was basically a form of racial stereotyping. And they claim this triggers something called strict scrutiny.
Strict scrutiny. Now, for our listeners who might not be legal experts, what does that actually mean?
Well, it means the government has this really high bar to clear whenever they're using race in their decisions. It's not an easy hurdle to jump over. And those challenging the map, they were arguing that Virginia couldn't meet this strict scrutiny standard for a lot of the districts. They were pointing to certain instances where it seemed like they were just drawing lines straight through racial demographics.
And the district court, the first court to hear this case, they didn't just buy the legislature's explanation. They went through each of those 11 districts with a fine-toothed comb.
Exactly. They did a really detailed analysis. And they concluded that race was the main factor in drawing those district lines. They weren't convinced by the reasons the legislature gave. And they even said that the House's witnesses seemed, well, less credible in a second trial on the matter.
Now, here's another twist. The lawyer representing Virginia argued that based on Virginia law, only the Attorney General can represent the state in appeals like this one. And they pointed out that the House of Delegates had never claimed to be representing the state's interest until their right to appeal was questioned.
It's like they were challenging not just the content of the case, but who had the power to bring the case forward in the first place.
And this is what led to those tough questions from the Supreme Court justices. They weren't just focusing on whether racial gerrymandering happened. They also wanted to know if the House of Delegates even had the right to bring this to them. That's the whole standing issue.
Yeah, and they were also asking about the Attorney General's role in all this.
Yeah.
And they were really interested in why that 55% BVAP target was just kind of applied to all the districts the same way, without taking into account the specific context of each district. They also were digging into how much weight they should give to the lower court's judgment on whether witnesses were credible or not.
So Justice Sotomayor, for instance, she brought up a really important point. What if any legislative body could just appeal these decisions whenever they wanted? wouldn't that lead to a whole lot of chaos and confusion within state governments?
Absolutely. It would get messy.
And then you've got Justice Alito. He was really pushing the House on their claim that they were representing the whole state's interests.
Right. And he seemed a little uncomfortable with the idea of the Supreme Court having to figure out Virginia state law to decide who could speak for the state in cases like this. It's important to remember that federal courts usually try to avoid stepping on the toes of state courts when it comes to matters of state law.
Exactly. And Justice Kagan, she zeroed in on that 55% target. She was basically asking, is there a good reason to use that number across the board? Or should you have looked at each district individually and explained why that target made sense in that specific context?
And Justice Breyer brought up a really practical issue that I think is worth considering. How should higher courts handle situations where lower courts have already made decisions about whether or not they believe witnesses, especially when there have been multiple trials? It's tricky for an appeals court to second guess what happened in the courtroom, where the judges saw the witnesses firsthand.
Right, that makes sense. Now, Justice Kavanaugh, he dug into something that could be seen as problematic about that 55% target. He pointed out that to ensure minority voters can actually elect the candidates they want, you often need more than a simple majority in majority-minority districts. He also brought up that the U.S. Justice Department had given their okay to the plan initially, but he clarified that this approval only looked at whether the plan reduced minority voting power overall. It wasn't about whether it was racial gerrymandering.
Yeah, and those are two very different legal questions.
Oh, absolutely. And it's important to distinguish between them.
Yeah.
It was also brought up by those opposing the new map that the state Senate's district plan, which was passed at the same time as the House plan, well, it had BVAP percentages consistently under that 55% mark. Their argument was essentially, hey, even the legislature itself realized you could have lower percentages and still be following the Voting Rights Act.
Yeah, they were trying to show that the House plan wasn't the only way to do things. It raises some interesting questions about the House's choices, right?
For sure. And at the end of the day, this whole case really highlights a crucial balancing act in our democracy. We have the Voting Rights Act, which is all about making sure minority groups have their voting rights protected. And then we have the Constitution, specifically the Equal Protection Clause, which says that the government can't use race as the main factor when drawing district lines.
And that's a tricky area of the law to navigate.
Oh, it definitely is. But as we mentioned at the beginning, the Supreme Court ended up upholding the lower court's decision. But here's the thing. They didn't make their decision based on whether or not there was actual racial gerrymandering. They said the Virginia House of Delegates didn't have the legal right, that standing, to even bring the appeal in the first place.
So they basically sidestepped the really big question of whether racial gerrymandering happened.
Exactly. And because they decided based on this standing issue, they didn't give a final ruling on the main question of racial gerrymandering.
But what that means in practice is that the lower court's ruling, which said it was unconstitutional racial gerrymandering, well, that still stands. So those districts will likely get a new map drawn up by a court for future elections.
Okay, so now it's time for our 10th chair segment. Imagine for a second that you're the 10th justice on the Supreme Court, maybe a little less constrained by all the legal technicalities. What would your take be on this whole case?
Okay, so if I'm putting on my 10th chair hat, I'd say that even though legal standing is super important, and we don't want courts meddling in state government business, the real heart of this case is about fair and equal representation. That's what really matters. And when you see that 55% black voting age population target being used for all these different districts without much consideration for the unique characteristics of each place, and you combine that with the district court saying they drew those lines based on race, well, that raises some serious red flags, even if the goal was to follow the Voting Rights Act. And that is a critical goal. Using this kind of rigid mathematical approach could end up prioritizing race in a way that overshadows other important things about districting, like making sure communities with shared interests stay together or respecting the boundaries that already exist. It feels a little too much like a one-size-fits-all solution, and that doesn't really work when you've got different communities with their own unique demographics and voting patterns. It makes me think that a more tailored approach, where they analyze each district individually and consider the specifics of that area, would be much better for achieving truly representative democracy. This case shows us that to get real fairness and representation, you need a nuanced approach. You can't just rely on hitting certain numbers. It's much more complex than that.
And that was our deep dive into Virginia House of Delegates v. Bethune-Hill. We hope you have a clearer understanding of the case and why it's so important.
This case really shows us that there's this constant push and pull between ensuring fair representation and protecting voting rights in our elections. And figuring out how to do both is a huge challenge.
What were some of the things that stood out to you the most in our deep dive? Did this spark any new questions in your mind about how we draw those electoral district lines and all the challenges and stakes involved?
Join us again next time when we explore another fascinating and impactful case that shapes our legal system.
And if you found this breakdown helpful, don't forget to share it with anyone who's trying to make sense of the law without getting lost in all the legal jargon. We'll see you next time.